Fuck my life. Um, so yeah, I am using AI to break law, not the law, just law, because it needs to be broken. It needs to change. This shit's a joke. All you lame ass judges that think you're fucking so much better than everything when all you are is a referee. I don't understand why you're not held more accountable than everybody because you know better. Same with the lawyers. Professionals should not get the fucking pass to be whatever they are. That makes them think they're above the law just because they studied it. You would think that would make them 10 times more likely to have to fucking follow it. Otherwise, you're fucking hate. But you study the law, you're the only one that knows the law, so therefore you make the law, and nobody knows what it means until they do. The Nunk was on the ninth. That's my poopy. Come on. The poop. Get here. Whatever. Fuck you guys. Alright. Let's see what we got.
3, Off-record decisions and nunc-pro-tunc abuse, judicial revisionism in action. During the December 5th, 2024 hearing, Judge Breslow made several critical decisions entirely off the record, circumventing transparency and due process. Specifically, after barring Mr. Church and his witness from fully participating, Judge Breslow privately conferred with counsel without Mr. Church present or aware, and unilaterally decided to order a competency evaluation and set a subsequent hearing. Mr. Church explicitly opposed this evaluation, but none of his objections were noted or recorded, effectively silencing his voice. To compound this misconduct, on December 9th, 2024, Judge Breslow signed a written competency evaluation order purporting to have been made openly in court on December 5th, 2024, nunc-tunc. This retroactive order deliberately omitted critical details, such as the unlawful exclusion of Mr. Church's witness and his vocal objections, and instead falsely portrayed the hearing as routine and uncontested. This strategic manipulation of the record is a blatant abuse of nunc-pro-tunc authority, which Nevada courts clearly state is exclusively for correcting minor clerical errors, not for rewriting history or concealing judicial misconduct. The improper use of nunc-pro-tunc orders to fabricate procedural legitimacy after the fact not only violates Mr. Church's due process rights under the 14th Amendment and the Nevada Constitution, Art 1, Sec. 8, but also potentially constitutes federal obstruction of justice under 18 U.S.C. 15999, given that the court knowingly produced a misleading official record. Violations include NCJC Rule 2.5, failing to competently and diligently maintain an accurate court record. NCJC Rule 2.9a, engaging in improper ex parte communications and decision-making without the defendant present. NRS 7.095, mandating that all criminal proceedings be accurately recorded, which was knowingly bypassed here. Nevada Supreme Court rules requiring verbatim records in criminal proceedings, clearly violated by these off-record maneuvers. Ethical duty of candor, judicial obligation to avoid knowingly signing misleading or incomplete orders. This deliberate and cynical rewriting of the record underscores a disturbing pattern of judicial misconduct, where transparency, fairness, and due process are not only neglected, but actively undermined by Judge Breslow.
Are you a poopy? She's a poopy. okay, Poopy. Sorry. It's okay. It's okay, Poopy.
Nosher 4. Contempt threats and judicial intimidation to silence defense, judicial bullying disguised as decorum. Throughout this case, every time Mr. Church exercised or even attempted to exercise his fundamental rights, Judge Breslow predictably retaliated with threats and intimidation. On December 5th, 2024, when Mr. Church objected firmly but respectfully to the unlawful exclusion of his key witness and his own silencing, Judge Breslow swiftly threatened contempt, explicitly raising the specter of incarceration to silence valid protest. It wasn't decorum was protecting. Rather, it was his personal comfort and control over the courtroom narrative. Earlier instances reveal the same troubling pattern. Whenever Mr. Church filed pro se motions articulating legitimate grievances about ineffective counsel or systemic failures, Judge Breslow harshly admonished him, declaring he was not allowed to file anything independently while represented. These admonishments weren't neutral procedural clarifications. They were deliberate warnings, laced with implicit threats of punitive sanctions, clearly intended to discourage Mr. Church from further highlighting judicial and attorney misconduct. Such intimidation directly contravenes well-established precedent. The U.S. Supreme Court in Mayberry v. Pennsylvania, 400 U.S. and 455, 1971, emphasized that a defendant's outspoken criticism of judicial unfairness, even if heated or uncomfortable for the court, frequently reflects justified perceptions of injustice. It is precisely these perceptions, especially when raised respectfully, that courts must carefully accommodate, not punish or silence through contempt threats. By issuing threats, Judge Breslow merged the roles of accuser, prosecutor, and judge, creating a glaring conflict of interest and violating fundamental 14th Amendment due process protections and corresponding guarantees under Article 1, Section 8 of the Nevada Constitution. Moreover, these threats flagrantly breach several ethical obligations, including NCJC Rule 2.8b, requiring judges to exhibit patience, dignity, and courtesy. Sarcasm, threats, and overt hostility toward defendants raising legitimate concerns violate this core standard. Nevada Rules of Professional Conduct, NRPC, Rule 1.16a3. A defendant has an unequivocal right to discharge ineffective counsel. Judicial interference, particularly through threats of sanctions or contempt, directly undermines this fundamental right. Even absent a formal contempt finding, Judge Breslow accomplished his objective. Mr. Church was systematically discouraged from voicing justified concerns. This use of judicial power to silence valid dissent is textbook oppression and represents a profound ethical and constitutional breach. Violations clearly documented. U.S. Constitution, Amendment 14, Due Process Clause. Nevada Constitution, Article 1, Section 8, Due Process and Right to Fair Hearing. NCJC Rule 2.8, Judicial Demeanor and Fairness. NRPC Rule 1.16a, 3, Client's right to discharge counsel without interference. Ethical conflict of interest. Self-protective judicial intimidation. Such repeated calculated judicial bullying isn't mere procedural error, it's judicial abuse of the worst kind, warranting prompt disciplinary inquiry and correction.
All right, sorry about that, dude. I'm just so fucking exhausted from my life.
Resistance from their existing social circle, and then this decision whether they want to socially shed, which means letting some of those people go.
But it's cool.
If we were born at any other time in history, you would grow up in a town, get a job